Yeah, we're live.
Very good. Again, welcome everyone to another edition of Intellectual Property Law. We're continuing with the trade secrets conversation, and so last the first session that we had, we kind of in general talked about intellectual property law and all that. And then a couple of weeks ago, we had our first session on trade secrets law. And we talked about the elements of trade secrets law and how it evolved out of torts and how the courts today are moving away from the tort view and adopting the Uniform Trade Secrets Act view. We talked about a case from the Utah Supreme Court. That case is just a representative case that you see from Supreme Courts of many other states, in which they make a clean break from treating trade secrets as a tort and say no, it only has to be analyzed under the Trade Secrets Act. So that kind of started out our trade secrets discussion, seeing how the courts today view trade secrets and what kinds of analyses they set up and they go through. And so so today basically I'm going to talk about three cases that come from different parts of the country, and they will talk about one aspect of trade secret law, which is determination of ready ascertainability. The the slides are posted to the top, and when I say slide number, it basically uh, is the slide in the series. So slide number one is the title, and we go to slide number two. And as we discussed the last time, these are the elements of a trade secret, that it has to confer independent economic value by virtue of it being a secret, and it should not be generally known nor being readily ascertainable, and it should not be obtained by improper means, and it should be subject to reasonable efforts to maintain its secrecy. So if you if your information satisfies these 5 points, then you have a trade secret on your hands. So when we look at the cases and where the litigation is, so basically trade secrets doesn't come into play until somebody misappropriates somebody else's trade secret and there's a lawsuit. That's the first time, and that we basically analyze whether the information that we're talking about is a trade secret or not. And so the disputes that we see in the courts, they don't deal with independent economic value, nor do they deal with not being generally known. And really, it makes very logical sense. If this information did not have independent economic value, you wouldn't go through all the time and expense of litigation to sue the other side, and the other side wouldn't have gone through the trouble of misappropriating it. So the fact that we're in the court today arguing over this information means that it has independent economic value. You can never go to the court and argue it didn't, because the first question is, well, why'd you take it if it didn't? So that is not argued in the courts, nor is being generally known, because being generally known is really objective. It's like, well, is it out there? Is it not out there? That is very little dispute if you show a website that has the information. You say, well, it's generally known because it's on the internet. So the last three elements of a trade secret law is where all the litigation happens, and that's where all the arguments are. And when you look at them, you can see why that is. Well, what does it mean to be readily ascertainable? How readily ascertainable should something be for it to be readily ascertainable under trade secret law? And so you see that you can have a whole bunch of different arguments on where the line should be drawn there. Same thing with proper means and improper means. Well, what do you mean by improper means? Does it mean illegal means? Can something be legal and still be improper? Can something be immoral but be proper? Then you get a lot of arguments there. And reasonable efforts. Every time you see the word reasonable, you see that that's put in there specifically for litigation purposes. So when the legislature drafts this law, they know that they have to put vague terms in here and allow the courts to basically view this on a case by case basis and on the basis of justice. Would justice tell us that this would be readily ascertainable or not? Would justice tell us that these efforts were reasonable efforts or not? And the people who determine whether it's justice was served or not is the jury. So readily ascertainability, propriety of the means, and the reasonableness of the efforts, all of those are governed by society norms, which the jury represents that. So today we're going to focus on the first of these litigious points, and that's ready ascertainability. So on slide 3, we start with the case of Amico Productions v. Laird, Indiana Supreme Court, 1993. So slide number 4 sets out the facts of the case. And so Amico was, which is based in Indiana, was trying to explore oil fields in Texas, and they hired Clendening and other people who went through several years of intense geologic studies and mapping and this and that until they identified all the fields, and they circled them, and they decided that they weren't in a position to exploit all of those fields. They just wanted to exploit part of them, and so they leased only a part of those fields and left the rest untouched. Clendening, who was part of this team, had also identified fields that were outside of Amico's area of interest. And so he basically kept going to Amico saying that, look, these other fields are also really good fields, and you should put them in the program. And Amico, for whatever reason, we don't really care what that reason is, decided they didn't want to do that. And so Clendening got really pissed off. He left Amico, and he took the map of these fields with him, and he went to this guy named Laird. Laird was a leaseholder of oil fields in Texas. And so Laird basically leased the fields that were both in the Amico area of interest and the fields that were outside of Amico's area of interest. So a little time goes by, several years. Amoco is now ready to exploit those fields, goes back and sees that Laird is the leaseholder for all of those and is basically squatting on those fields, saying, give me a whole ton of money and I sublease them to you. They're taking Amoco hostage. Amoco tries to figure out how Laird figured out that these fields existed and figures out that Clendening gave the map to Laird. And so Amoco sues Laird for the misappropriation of Amoco's trade secrets. So the first question here is, why is Amoco not suing Clendening? Shamash or Benjamin, do you guys have an answer for that?
I'm not sure. Maybe because he's not the one who benefited, like financially
No.
speaking. Okay.
No, he did because he got paid for giving the information to Laird. Because Clendening is judgment proof. Clendening doesn't have enough money to pay all the damages that Amoco is going to be entitled to. And whereas Laird is a very, very wealthy individual and he can pay. So
So
basically,
simply they picked the fattest cow and sue it. Is this how it
absolutely,
works?
you go after the deepest pocket, uh, and you forget about what Clendening did. I mean, you bring in the wrong acts of Clendening as part of your lawsuit against Laird. So these are the facts, and usually in a law school class, a student is responsible for this case, and so the student presents the facts, and if the student is missing some of the facts, I ask questions, and so the facts all come out, and then we start the discussion kind of like this by, well, why isn't Clendening sued? And then the student tries to answer. Uh, we go back and forth, and then I open it up to the rest of the class, see who else has uh, an idea about this. And so we get a discussion going, and then we go to the next point. This is called the Socratic method of teaching that law school professors are so fond of. And it really lends itself really well to exploring legal issues. Anyway, this not being a law school class, I keep on lecturing and say, well, what is the issue here? Uh, and the issue is, was this a misappropriation of trade secrets by Laird? Right? So Amoco is suing Laird for misappropriation of trade secrets. And so the question is this a misappropriation of trade secrets? And so I talked about this wait a minute part uh, in the last slide. So I'm not going to talk about that. Okay. So slide 6, we go to Uniform Trade Secrets Act, and we look at what misappropriation is. And I have highlighted the important passages so it's more readable. So misappropriation means use of a trade secret of another without express or implied consent by a person who at the time of use had reason to know that his knowledge of the trade secret was derived from a person who had utilized improper means to acquire it. So what the hell does that mean? We go to slide 7, and I have translated that for this case. So misappropriation is use of a trade secret of Amoco without express or implied consent. That express or implied consent by Amoco, by Laird, use of trade secret by Laird, who at the time of use had reason to know that his knowledge of the trade secret was derived from clandening who had utilized improper means to acquire it. How did uh, Amico know? How did Laird know or had reason to know that the trade secret was derived utilizing improper means? It's because the trade secret is that the trade secret that was, or the information that was relayed to Laird is of such nature that Laird, who is a sophisticated player in the oil business, should have known this is confidential information, and so he had reason to know that clandening was not properly in possession of these. And in fact, I think there was an issue of they had a conversation about that clandening actually explicitly had told Laird that that he stole it. So that is the law on misappropriation, and so if you look at this, we see that yeah, Laird did use. Let's just gloss over the term trade secret and just call that confidential information. So we see that yes, Laird indeed used confidential information of Amico without having express or implied consent of Amico. How did he use that? He used it by offering the lease to the fields that were covered by the confidential information back to Amico, trying to get money from Amico. So that's a use of the information, and at the time knew. So 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 there isn't really any dispute over any of this, what Laird did and how clandening acquired the information. You can't really argue that clandening had access to those maps when he didn't. So the argument rests, as we see on slide 8, is whether the information was a trade secret, so that this misappropriation will apply to it. On slide 9, we go through elements of a trade secret. Did this information have independent economic value? Yeah. Knowing where the fields are is incredibly valuable. In fact, Laird was trying to sell that information. Was it not generally known? That's true. It wasn't published that these oil wells exist or oil fields exist. Was it readily ascertainable? Let's put a pin on that. Was it obtained by improper means? Yes. And was it subject to reasonable efforts? And the answer is yes. I mean, Amico's policy on keeping confidential information confidential is, as you might expect from a company of the size of Amico, that's pretty airtight. So really what we're going to be dealing with is ready ascertainability. So on slide 10, in order to see whether this information was a trade secret, we have to ask the question of, was the information readily ascertainable? So Laird is arguing that the same way that Amico went through the studies and figured out where the oil fields are, anybody else could have done that, could have done that study, and therefore if it would have been readily ascertainable. The court says not so fast, because slide 11, where the duplication or acquisition of alleged trade secret information requires a substantial investment of time, expense, or effort, such information may be found not being readily ascertainable. So Amoco took years, and a team of geologists and oil engineers, etc., petroleum engineers, etc., and an expenditure of several $1 million during those years to identify these potential oil fields, because Amoco knew that the exploitation of those fields would bring in profits much greater than that. But we can't deny that Amoco went through millions of dollars of expenditures and several years of intense geologic studies to figure those things out. So the court says when you have to do this, it's not readily ascertainable. Because why? Because not any Joe off the street can do that. Only a certain group of people can do that, people who with very deep pockets and access to geologists. So it's not readily ascertainable. And the court here gives a really good uh, what do you call it, marker that says information is readily ascertainable if it is available in trade journals, reference books, or other published materials. So these days, what we say is that it's readily ascertainable if it's on the first 2 pages of your Google search.
Can I
When
can
you,
I ask a quick question, Sam?
yeah, go ahead.
Okay, so let's say I heard a rumor that there were those fields, and then I did my own study. Would that change the course of this judgment?
No, because something that is independently discovered is not cannot be a trade secret. So
So,
so
so, so, so the discovery here is, oh, you have to actually establish those facts as you know them. You can't just use the facts. So here's what I'm saying. Like, if I tell you that there's a rumor, and then you say, hey, I'm going to fund my own study to verify your claim, and then my study agrees with your quote unquote rumor, um, would that still be
how
use
did
of
you
trade
how did
secret?
you hear that rumor?
Well, that's the thing. Like, is that something that's defensible? You can say, "Hey, I heard it from this guy, but I didn't just take his word for it. I did my homework." Does doing the quote unquote homework affect these kinds of outcomes?
So what you're saying is because of the presence of that rumor, it becomes questionable. But then again, this ready ascertainability becomes very important, and then the question is, what did you hear and what did you discover, right? So the thing is that what you heard has to be commensurate with the information that you get to use at the end. So if you hear
Because I
that,
feel like you can play fast and loose with this. Like, hey, don't show me the map. Tell me without describing the map too much, and then you can play those kind of cheeky games that I've seen them be played. And so that's why I'm asking, because that feels like a kind of a dishonest way to navigate through this, but a way
well,
that some people operate.
I was with you all the way until you said dishonest, because that's what I do. Right?
Well, I'm
That's
saying
how
the
I
people that
advise
I've
my
heard are
clients
dishonest.
how
Yeah.
to get around other people's trade secrets and without misappropriating it. And so if the law provides you that if the law is providing you with loopholes and you are taking advantage of those, then we usually say chances of that being unethical is low. I'm not saying it's not, because legal and ethical don't overlap all the time. There's substantial overlap, but there are areas that they don't overlap, and so uh, the legal part is my professional uh, conduct, and the ethical one is my personal one. So in any event, the outcome of this discussion of this case is that if you have to spend substantial time, effort, or money then the information that you get is not readily ascertainable. And so that leads to the conclusion that just because it's economically feasible to do something, right? It would have been economically feasible for LERT to do that, to do the tests that Amico had done. But just because it is economically feasible doesn't mean that the information was readily ascertainable.
Okay, that's very interesting. So that really sets the stage for, I think, creativity, for creative workarounds as you described your job being. So thank you for that clarification.
So I want to step back and say the purpose of intellectual property law is creatively getting around intellectual property. That having intellectual property causes other people who want to do what you're doing to come up with creative ways, new technologies, new inventions to do what you're doing. If there was no intellectual property, everybody would just do the thing, and it would be just economic advantages that would lead to innovations, and that's too slow. Having intellectual property actually leads to really a fast technological development. We have great deal of examples throughout history. I won't go into them, but take my word for it, that's true. So on slide 12, the court gives us an additional gift and says, you know, you can have trade secrets when all the components of the trade secret are known, but the combination is not known. That is, so your trade secret is the specific combination of known information. And so when we get to patent law, you'll see that that is also a thing of patentability, that if you are putting known components together, you could in fact make a new and patentable invention. So anyway, any questions so far before we move on? Anything in the chat? Nothing in the chat. People come up and kind of join the conversation, so it's not just me lecturing. Anyway, so if there are no questions, we go to the next case, which is kind of the last case. I'm only talking about.
Do you know? Sorry, Sam. I did not know you were moving on. Do you know like what was the final judgment on this? Like what was the final settlement? How much money are we talking about?
So the final judgment is that Laird had misappropriated Amico's trade secrets. And so I don't know what the actual judgment amount was, because after this is done, it goes back to the district court for the damages phase of the trial. And so that's a completely separate set of cases that comes out of that. So I didn't pursue that because it's not of interest to me how much money. But it was several $1 million, if not over 100 million. So.
Wow. All right. Cool. Thanks.
Yeah. Okay. CDI Energy versus West River Pumps. I like this case because a lot of us who have worked and have left work and have had clients follow us to the new place have faced these challenges. So for us lawyers who leave a law firm and go to another law firm, or leave a company and go to another company, we really worry about how to structure the transition so that we don't run into issues that we see in CDI v. WRP. So what are the facts of this case? CDI does oil stuff. I just say oil stuff because they provide services and upkeep and this and that to oil wells, domestic oil wells. And CDI is, I believe, I forget where they're from. It doesn't really matter. But they want to get into the South Dakota oil field business. And so they hire 3 people in South Dakota from other South Dakota companies to start the offices for CDI in South Dakota. Oh, yes, CDI is in Montana because there's like close to 200 miles between the CDI office in Montana and these guys in South Dakota. And the thing is, before these 3 guys, CDI had no other connections with South Dakota, and people from the CDI main office rarely visited the South Dakota office, if at all. So the South Dakota employees came with the know-how of their job. They knew how to do their job, and in fact, it was for this reason that CDI hired them. And the fact was that during their employment with CDI, CDI did not provide any training for them, no classes, nothing, no education. So basically, any know-how that they had remained the know-how that they had when they came to CDI. So those 3 guys kind of see that they're being screwed by CDI. There was bad blood. And so they go ahead and set up a new company called West River Pumps, or WRP. And before they leave CDI, they tell their customers that they're leaving, give them their contact information, and then they leave. And all the South Dakota customers that CDI had leave with them, and they go to WRP, and they continuing their business development, and they have additional customers of their own. So CDI is not happy because they lost the South Dakota business, and they claim that they could have manned that office to take care of the clients who were there, but these guys basically stole their trade secrets. What are the trade secrets? The know-how for how to do this, how to do their job, and the customer list. On slide 15, we see the same questions that I asked, but I just put down one sentence from the court that says the information at issue was of the type that may, in some industries, be treated as trade secret information. Customer names, contact information, pricing information. So actually, customer lists are one of the biggest trade secrets that a company has. And it's guarded very well. And a lot of the trade secret litigation that we see is this scenario, that people leave and they take the customer list with them. And usually those people lose out because customer lists are highly protected and protectable trade secrets. So two questions come up before the court. The first one is the issue that we're discussing, that was the information readily ascertainable. And the second issue is basically a segue to next week's session, that was the information subject to reasonable efforts to maintain its secrecy. So next week we're going to be talking about this. And the court kind of bifurcates the issue on slide 16. And we have two potential trade secrets at issue here. The first one is customer list. The second one is know-how. So customer list, the court says, the South Dakota oil business is a very small market. Everybody knows everybody. These guys knew everybody. It's kind of like you walk in there, you open up the yellow pages, you can determine the customer list from that. So the customer list was readily ascertainable. If this were, oil companies globally, then you would say no, because there are like gazillions of them. But this is just oil companies in this corner of South Dakota. We all know who they are, so this was readily ascertainable. And so the customer list, because of its ready ascertainability, was not a trade secret. How about the know-how? The court said, look, CDI made no expenditure for developing the know-how. They came to the company with the required know-how, and in fact, they were hired because of their know-how. And so the know-how was their own information, and it was not CDI's trade secret. So on ready ascertainability, CDI loses. CDI also, so let me first stop here and say any questions on the ready ascertainability aspect of this information. All right. So then we go to reasonable efforts. CDI says, hey, I told all of my employees to keep the information secret. WRP is able to show that CDI's offices, both in South Dakota and in Wyoming, were open. That is, people off the street could go into the offices without being escorted. Once you went in there, all the information and material were strewn all over the place. The computer monitors were not polarized, so you can't see it from an angle. None of the documents were marked confidential. And people routinely took them home without checking them out and brought them back. And so therefore, those were not reasonable efforts to maintain the secrecy of the confidential information. So for both of these reasons, the trade secret fails. And there was no trade secret, and so no trade secret was misappropriated.
Wow, that sucks. I didn't even think of that, Sam. To say like, hey, you have to have privacy screens, you have to have all the security, because that in itself fundamentally undermines your claim of a trade secret. That's wild.
Yep. Yeah. So this is why companies are so anal about you having to check in at the front desk, write your name, who are you visiting, what time did you come in, what department, and then they give you a visitor badge. The visitor badge is so that everybody else knows you are not privy to their trade secret, and so as you come closer, they stop talking. They turn the screens. They turn the papers over. And when you go back, they go back to what they were doing. You always have to be escorted. You can't just roam around a company because of trade secrets. Most companies you go into, you walk into the reception area, and in that reception area is are bathrooms and a conference room, and you're mainly staying in that conference room. You don't go in the back. Why? Because you're exposed to no trade secrets. And if you want to go in the back, you have to use your badge to key in so they know exactly who went in at what door at what time, and who had access to what information at any given time. So these are all the things that we say, oh, this is security, this is security. These are all trade secret protection efforts that through years and years of litigation and these things that, hey, your efforts were not reasonable, we now have this set of practices for when you visit a company, so as to their efforts seem to be reasonable.
Sam, if CDI had trained their employees, let's say they made some workshops, it doesn't have to be something serious, right? You know, these bullshit workshops that companies do, and they claimed that through these workshops they gave their employees knowledge, so they increased their skills, and explicitly trained people to protect those trade secrets. Is this an argument that could be made here? Okay, we don't have security at the door, but everybody knew that they had to keep things private.
Yes, that would have bolstered it somewhat, but as you see on this slide, on slide 17, the first line is that they did give the people trade secret training, as in you shouldn't disclose it, but that wasn't enough, right? So the company had to do more, had to actually prevent people from having access to their trade secrets. So just giving seminars and training was not considered to be reasonable efforts. So I want to take a very small detour for the last 4 slides and the last 10 minutes, and talk about law and equity. This is something that I had no idea what they were until I went to law school. So this case, both of these cases, especially the reasonable efforts, is something that rests on equity. And so let's figure out what that is. If you have ever read the U.S. Constitution, you see law and equity appear in 2 different places. One is Article 3, Section 2. Article 3 deals with the judicial branch, with the courts. Section 1 says you have one Supreme Court and it has one Chief Justice of the United States. That's the extent of federal judiciary in the Constitution. Everything after that is by federal law. And so it says that judicial power shall extend to all cases in law and equity arising under the laws of the United States. And the 11th Amendment says the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted by the United States, etc., etc. So what's the difference between law and equity? The difference is historical. What we see in 19 in medieval England, laws provided relief only in terms of financial restitution. So they would see how much damages you have incurred, and the defendant had to pay the plaintiff the money to set the plaintiff right, make the plaintiff whole. But soon they found out that this type of justice doesn't work all the time. Sometimes you want somebody to do something. Hey, he signed a contract to build a house for me. I gave him the down payment, and then he took off. Where is he? Right. So I'm suing him to come back and perform on that contract to build the house for me. Or sometimes we want the defendant not to do something, right? He keeps walking on my property. His cows keep grazing on my land. Stop him. So that if I give you monetary damages for the cows grazing on your land is not going to make you whole, because you still don't have grass for your own cows. And so we need to stop the guy from bringing his cows onto your land. So what people did increasingly is appeal to the king and the king's justice, and say, yes, the law says this, but justice and equity dictate that the result should be something else. Kings had in England their what we today call prime minister was called chancellor. And St. Thomas More is one of the most famous chancellors. He was chancellor to Henry VIII, and he's now the patron saint of the legal profession. So St. Thomas More's really important contribution to the corpus of laws is the development of this body of equitable laws. And what we do today as equity most of it comes from what St. Thomas More did. So you went to the court or the hearings set up by the chancellor, and then these hearings kind of grew mushroom-like because they were working really well. So they became known as courts of chancery, because the chancellor was at the head of that system. And you would say, I appeal to the justice of the court. I'm being wronged here. Make me right. So this, as I said, requires either specific performance or payment for unjust enrichment, or give an injunction or a restraining order. All of these are equitable remedies for the plaintiff. So in this case, on slide 20, we see that CDI is seeking an injunctive relief. Meaning what? Meaning that CDI is not saying that, give me back the money that I lost because of this competition. CDI is saying, make them stop working in the area that I'm in. So make them stop working. That's an injunctive relief, a restraining order. And injunctions, as we said, are equitable remedies. They're not remedies at law, they're remedies at equity. So throughout the centuries, equity has developed some customs. And one of the customs is that one who seeks equity must do equity. Meaning that if you are coming and you're seeking the justice of the court to set you right, you should have acted justly in this process. And the other one is, one who comes into equity must come with clean hands. So both of these means that you can't just go out there and be an asshole and rip everybody off and be a total bad actor. And then when somebody wrongs you, you come to the court and say, hey, they're playing unfair, and you ask the court to right the wrong for you. Uh, there's some subtle political inferences there. But so in this case, CDI is not playing cleanly. CDI did not do what it was supposed to do. CDI did not train them, did not provide means for advancement, for career advancement for them. CDI did not protect its own trade secrets, did not have CDAs, did not hide the documents, etc. So CDI has not done equity and does not have clean hands. And so when CDI comes in and says justice, then the court says, even if what WRP is doing is unjust, because you are not in a position to seek the court's justice, I'm not going to give it to you. So that is kind of a concept that's somewhat unique to countries that practice common law, British common law, or English common law, I should say, because it comes from that. But it's extremely important in U.S. Practice of law, and in fact, up until 60s and 70s, when you would file a lawsuit, you needed to say whether you're filing it in law or in equity. The U.S. didn't have a separate court system for law or equity, but the same court applied different legal principles if the case was in law or equity. Right now, we don't specify that because we all know what kind of remedies are in law, what kind of remedies are in equity, and it could be both, right? You could ask for monetary damages and an injunction. Most patent cases are like that. It's like give me the profits that I lost, and also don't infringe again. So on the last slide, slide 21, I'm going to summarize the ready ascertainability. Oh, I'm sorry, I took out Symantec. It doesn't matter. What we saw, what that the court in Amico told us, even if something is economically feasible, that doesn't mean that it's readily ascertainable. In Symantec, which we didn't go through, had we gone through it, we would have figured out that if it's technically feasible to do something, that too doesn't mean that it's readily ascertainable. And then CDI tells us that it was dealing with limited number of customers, but we basically expand that and we say, if you have limited number of options that are available to you, and those options are known to anyone and everyone, then it's the information is readily ascertainable. Okay, this concludes my speaking part, and the floor is open for questions. Hello, Jim. Welcome. I sent you an invite. If you want to come up, you're more than welcome.
Hello, Sam. Nice to be here.
Thank you.
Everybody should know that Jim Mullen is my law partner, law firm of Mullen and Tahmassebi. So we welcome him for the first time on this stage. And everyone should know that I'm a much better lawyer than he is.
Better looking and more humorous.
My lecture was so clear that nobody has any questions. You see that?
I mean, not even I have questions. Can you imagine?
So let's talk about Stanford president's misappropriation of trade secrets
You
as
want
it
to
was
you want to
public.
induct Jim on day one? No, I think we gotta take it slow.
I've known Sam for a really long time, and gentle is not in his vocabulary.
That's what makes me lovable. But Jim, so you know, Benjamin is of the opinion that because Stanford ex-president had committed fraud in some of his papers, and he was kicked out of its presidency, but the bio department kind of allowed him to exercise his return rights, then Stanford should be closed down. And in fact, Benjamin is of the opinion that any institution that publishes a paper that later is proven to be fraudulent and needs to be retracted, that institution should lose federal funding forever and ever and ever. All federal funding in all areas. Ergo, Benjamin's crazy.
I wouldn't go quite that far. Not crazy. No. I think Sam laid out the basic premise, which is that the federal government should not be using its guns and its military to collect money from poor people and give it to people who commit fraud. And if Stanford commits fraud, then so be it for Stanford. It's
So I
good,
have a
good
couple
for
of
the goose. Good
questions.
for the gander. Sure.
I have questions. Okay, first is, and I don't know the answers to these, but is the law, patent law is governed by the law of equity. Is trademark law similarly governed?
It's a combination because you both have monetary damages and you have injunctive relief.
Is there a concept under trademark law similar to inequitable conduct?
I don't think. No, I don't know of inequitable conduct because it is not being examined. I mean, the examination process is totally different between prior art and prior use, right? Prior use is Google searchable, prior art is not. And so I think the duty of disclosing a much more difficultly obtained information should be greater than something that's more easily obtained. No?
I'm having trouble with that concept, but let's just settle on, to the best of your knowledge, the answer is no.
Yes.
Okay. So let's put that aside for a moment. Your generous characterization of Benjamin's position that one bad actor at a university requires the federal government to withhold funding for the entire university, is that correct? Am I understanding that correctly? One bad apple spoils
You're
the whole.
understanding my characterization of Benjamin's position correctly, but
Okay.
Benjamin has to speak as to whether my
No.
characterization is correct.
No, I would not say that. I didn't say that, but
Okay.
Sam said that on my behalf. But I would offer that however high the fraud goes, is exactly how high the federal government ban on federal funding ought to go. Now, in the case of Stanford, the fraud went right up because Mark Tessier-Levine was the president. But in, let's say, Harvard, where you have Francesco Gino, another pretty famous case of fraud, that was in, I think, the psychology department. So in that case, I think it would be reasonable for the federal government to say that psychology department.
You're breaking up,
You're
Benjamin.
breaking up, Benjamin. Yeah. You're in the matrix. So I think
it was just temporary. I would just say as high up as the fraud goes, the federal government should protect the taxpayers. And it's like if the fraud is found at psychology, then the psychology is no longer available for funding. That seems reasonable to me.
Who adjudicates this, and what form of due process needs to be exercised?
Before we get to your question, I just want to make this clear that the big flaw in Benjamin's line of argument is that in the United States, at university, administrators have no power over a professor's funding or a professor's research. That is, a department chair doesn't control who gets how much money, doesn't control who does what research, doesn't control who publishes what and where. In the United States, each professor acts completely independently. In England, it's different. I'm not going to go into that. But in the United States, whether you're an assistant professor, associate professor, full professor, you are completely independent of the administration.
I think that's overly broad, but I see the point.
Give me a counterexample.
University resources are allocated for support staff.
Not if you have an NSF grant, because the NSF grant pays for that.
Support staff, square footage of lab space, which is allocated on a political basis, not merely on a dollar for dollar basis. So there's a political component to the distribution of those resources, and department chairs have the ability to put their thumbs on the scale.
Yeah, I mean,
can they? No. But
you can track a
that's
dollar,
hold on, Benjamin.
Track a tax dollar.
But can they prevent the publication of a paper? Can the department chair say you cannot submit this paper?
I think on its face, the way you're characterizing it, the answer would be no.
Especially if the person's tenured.
Practically speaking, however, depending on the subject matter that's being published upon, I can easily imagine administrative, bureaucratic barriers placed in the path of a
if it's politically dangerous for the university, right? Then I can see that. But
so you just admitted
a biology paper being published and you have fudged the data, how much control does the department chair have on the publication of that when on its face is not clear you have fudged the data?
Right. So, and I love busting your chops, Sam, but so basically you admitted that you're wrong, that you're
Jim, you and I have this in common. Have this in common.
I think all of Sam's friends and colleagues have this in common, but be that as it may. But no, you're right, Sam.
To be fair,
it's
Sam
because I lose arguments so rarely that when I lose, people have to celebrate and publish it in the New York Times.
Okay, Sherlock Holmes. All right. So Sam, I think the point you're trying to make is that if there's an individual PI who's engaging affirmatively in fraud, the chances of the chair knowing about it, or even having an affirmative duty to know about it, is pretty low. Is that what you're saying?
Yes.
Okay.
And
I
then
agree with
when
you.
it moves up, then you go from department chair to the dean.
Hmm.
Then you go from the dean to the provost, and then you go from the provost to the president.
Hmm.
Right? I mean, by the time you get to the dean, the dean has no fucking idea what anybody's doing in the department or
And
in all
arguably,
the
nor should they.
departments.
And arguably, nor should they.
Nor should they, because they don't control the academics, right? They
Exactly.
control the administration of the academics, not
Yep.
uh, especially in a country like the U.S. where academic freedom is such a sacred concept.
Allegedly.
Was a sacred
Right.
But they
concept
don't have.
until
Here's the
January
problem:
of
is
this year.
that Stanford doesn't have a constitutional right to help itself to the taxpayer's back pocket. So there's no constitutional protection. But on the other hand, taxpayers do have a constitutional right to be protected from their
There,
money being taken for them for reasons
Where is that right in the Constitution?
other than the common interest. Well, it's the no emolument clause. If you really need me
No,
to
no, no. No
put your nose
no,
in
emolument
that's
there.
not correct.
clause applies to the president. Doesn't apply
Exactly.
to
Exactly.
Stanford University.
Moreover, once the government agrees to provide resources to Stanford, then it does have a constitutional right for due process to have that benefit withdrawn.
But that agreement of funds to Stanford is predicated on a certain service being provided, and if that service is not being provided, then that contract stands unserved. It is unperformed,
So that
and
then there's a
the
breach.
government should not continue to give money to parties that do not perform.
How is that
But
adjudicated? How do we
no, no, no.
know
Hold
that?
on a second.
All right. All right.
We don't completely absolve people of all future contractual relationships just because they were in breach of one contract, right? We still allow, you know, we
That's true.
still people go through huge lawsuits that goes all the way to the Supreme Court because of breach of contract, and then you see the next year they sign a new contract. So
Or
just
even
because you
affirmative
breached it
fraud.
doesn't mean
E-
you're foreclosed from ever contracting with the other guy again.
Even affirmative fraud. You see this in the military industrial complex all the time, where you have makers of weapons of mass
Right,
destruction
but why
who
is it crazy? Why is it crazy for me to advocate for less fraud?
it's not. But on
Well,
the other
there
hand,
you
do you
go,
cut off?
Sam.
Do,
Not
do,
crazy.
not entirely crazy. It's just to have such a draconian um, remedy is crazy with respect,
Well, I would
because
argue it's not draconian
you're cutting
because
off your
Stanford doesn't
you're cutting
need.
off your nose to you're cutting off your
Yes,
nose to
but
spite your
but
face.
yes, but
Okay.
it's not draconian because A, Stanford doesn't need the money. They have plenty of cash reserves. Two, it wouldn't take very
That's
long
a
before
that's a
scientific.
that's a fallacious argument
Okay.
because the money that Stanford has is not in its general funds. The money
Well,
that
Stanford
Stanford
can move
has
its money
is
around without too much
tied
trouble.
up. What?
Look, the more important argument is that if it were consequential when people committed fraud in academia, then people would commit less fraud.
So the argument that I've been having with Benjamin is that word consequential. That is, Benjamin thinks that the only consequence here that is worth mentioning is a financial consequence. Whereas I'm of the opinion that for someone like the president of Stanford, the no no amount of financial damages is going to be as meaningful as reputational damage. The fact that we all now know his name and associated with fraud is reputational damage. You say, oh, he went back to the department. Yeah, he had return rights, and so he exercised his return rights. But the question is, does he have a research group? Does he teach anything other than intro to biology to freshmen? Where is his office? Can he get any NSF or NIH grants, right? These are a lot worse for someone in the position of Stanford president than, slapping him with a $2 million fine. He'll just pay the $2 million and there's like nothing more. But this is a lot more harsh for him.
Agreed. It's a better tool. Hello.
Wait, did I miss something?
Did you hear Sam's last thing? Benjamin, can you
No.
hear me?
Yeah.
Yeah, Sam was arguing that the reputational damage is worse than the monetary damage, or better said, is a more narrowly tailored remedy.
Okay, but what Jim may realize is what it means if the winner of the Tour de France is doping. It means that for as long as you haven't been paying attention, all the winners have been doping, and the way to win the Tour de France is to dope. And those dopers will guaranteed push out anybody who is riding a bicycle and not doping, because that's how competition works. So the fact that Stanford, and by a professor who was doping, who was just using Photoshop to make up research, in my mind, is sufficient evidence that everybody at the top is doing the same thing, because that's what the competition at the top looks like. And if you aren't doing it, you're not competing, because that's the
So,
nature of competitive advantage, is that you have to do all the things that the winners are doing plus more if you want to win.
and what does winning look like here? Getting the government funding?
Becoming, well, yes, but also becoming the president, becoming the dean, becoming the X, the Y, the Z. Yes, that's what it means.
So there's a joke
All the
in here
people.
about losing. There's a joke in here about losing a testicle if you're going to do those things, but at the end of the day, it, it's it. I'm not comfortable with your remedy here. It seems overly broad, where a more narrowly tailored um, remedy would suffice, and it's still not clear to me how you adjudicate these questions. Who decides that there's been systemic fraud here? How do you prove that?
Very
And the
strong.
other thing is, Benjamin, the thing is that a winner of the Tour de France, their performance on the tour is not dependent on who won last year's and who won the year before and who won the year before that. Whereas a scientific paper and a scientific discovery rests on a long line of scientific discoveries. And so if any of those were fraudulent, then those would not form the basis for future science because they just simply don't work. And so most people, when they run into this, they either say, hey, the PIs here made a mistake, they misinterpreted the results, or it was fraudulent. And there is no way
Wait. All I
looking
have
at
to
the
do to
paper,
disprove you
you,
is
you,
to
you
find
can't.
one study that is fraudulent, but also based on earlier fraudulent work. Like all I have to do is find one double fraudulent study, and
No, no, no,
I
no.
win here.
The thing is, I'm making a general
You're going to
argument.
agree with me from now on, and every time I come into a room, you're going to address me
I'm
as Ben the Great.
listen. I'm making general arguments. For any general argument, you can find exceptions. And so,
No. You were very clear. You said that there were
yeah,
0 cases
no, I
in
didn't say
which
zero
a
cases.
scientific paper
I didn't say zero
was
cases.
was.
I
Yes,
don't
I know.
know. I don't
You
know
said
where you came
because
up
of
with
their.
zero cases. But you have a
Well,
habit of
let's see if
coming
Jim
up
is
with
following
things
the argument. Jim,
that I
help
didn't
us out
say.
here. One of us is
No,
lost. Can you help?
because you've descended into minutia where the actual point is lost in arguing over the
Yeah.
minutia. You've kind of lost my interest. So,
Oh, Benjamin always does that. It kind of gets to a point that we all say, "Okay, we're done, Benjamin. No more conversation." Because it doesn't penetrate. This is not the first time we're having this conversation with Benjamin. It doesn't matter how many times you tell him how academic science is done, how publications are done, who reviews, all of that stuff. He still comes back with his original argument, not taking
I
into
mean, it is
account the
true. It doesn't
fact.
matter what you say. Mark Tessier Levine was still the president of Stanford. You can't talk your way out of that paper bag. So I don't know why you try.
I don't give a care. I don't give a shit really, because there are 3,400 universities about in the United States, and you're harping on one. So
which
what
does,
happened to the other
In
300
fairness, we brought
and
Harvard in with Francesco Gino.
3,399, right? They're all
We
doing
included Harvard,
okay.
Francesco
You now
Gino.
have two. What happened to those 3,398?
Oh, this list doesn't quit it too. Come on,
No,
this list just
the
goes and
thing
goes
is
and goes.
that you live in exceptions, and you're trying to devise a rule by looking at the exceptions. The thing is that the exceptions are just that. They're exceptions, meaning that the occurrence is very, very rare. You are pointing out to 2 out of 3,400. I would call that rare. If you were to show that the academic life of 3,000 of these 3,400 was fraudulent, then I would say, okay, we now have a problem on our hands and we need to fix this. But because mistakes in science happens, fraud in science happens, but the frequency of that happening is rare. And when it happens, it eventually fixes itself for the most part, then I'm not that concerned about it. I mean, you may choose to be very concerned and say that we live in hell and the world is coming to an end because this guy is Stanford's president. But I and most other sane people in the world don't share that.
objection.
Look.
Characterizing yourself as sane is unfounded.
I think I've been laying
Yeah,
out foundation for the past 2 hours here.
I
I
think the reason your argument fails here, Sam, is that the fraud is not evenly distributed. The people who dope in the Tour de France are not evenly distributed necessarily. The
Okay, get your hand
the
out of
problem is that
the
when you look at the people at
because
the
that
top,
analogy has absolutely nothing to do with the
You look at the
academic
people
world.
who are winning.
No, winning in the academic world doesn't mean anything. Listen, being the president of Stanford is not a winning position for most academics, because most academics hate administrators. So people who leave science and go into administration, they are considered scientific failures who left science and went into administration. So don't call president of Stanford and president of Harvard as winning, because they're not the winners. Who are the winners? The other people that you have a problem with, the Nobel Prize scientists.
Well, the Nobel Prize scientists all have the Nobel disease. They're all a bit kooky. But
Okay.
here's another challenge. Here's another
No. Hold on.
challenge that
Hold
you
on.
have.
This
If
is,
it was,
hold on.
if
Wait. Stop. We've been going for an hour and a half, and it looks like the conversation on trade secrets is over, and we're going into kind of Benjamin's looking glass world. And so I don't want the Benjamin conversation to be on the replays. So if we all agree, I will say goodbye and close this room, and then we can open up an after party room where Jim can get exposed to
that
Ben.
would be great. But can I just point out, you brought this topic up. I didn't do that.
Yeah.
How you doing?
And I will regret that fact for the rest of my life. Okay, everyone.
Well, thank you, Sam. I never imagined that studying law would be fun, but yeah, I'm enjoying these rooms. Keep going. Thank you.
All
Yes.
right.
So
Later.
keep in mind, next week, Tuesday, same time, 12 Mountain, 11 Pacific, 2 Eastern. We're going to have the continuation of trade secret discussion, talking about reasonable efforts to maintain secrecy. That should be the last or next to last session on trade secrets. And after that, we begin our discussion on patents. And then on Thursday, the same time, 11 Pacific, 12 Mountain, 2 Eastern, we have the chemistry room, and we're going to start our discussion on reaction mechanisms. We did reaction kinetics the last time, and so we're
Sorry,
going to use that information.
when's the chemistry room again? I bet that you went like
Thursday.
Thursdays. Okay,
Thursday,
same
yeah.
time?
Same time, yes.
Okay.
At noon my time. Okay. Thank you very much, everyone, for being here. And I invite all of you to immediately looking the Scientific Discourse house for the after party room. Have a